let's start by this series of Supreme Court decisions that were back in 1991 that have left us on, I want to say a slippery slope, but in some ways we're sort of ramping up since that time on these inclusions of mandatory arbitration agreements. In fact, let's start with what mandatory arbitration agreements are, and then we'll talk about the Supreme Court cases that began to, I guess, introduce this more widely into American contracts.
Sure. So mandatory arbitration is a term we use that tries to distinguish between a traditional situation where you might negotiate an arbitration clause between, say, two companies doing business with each other to resolve disputes. That's something they negotiate between two equal parties as a way to kind of more effectively resolve their conflicts. And it's used in a lot of settings. Unions and management use it. What's really different with mandatory arbitration is there's really no negotiation. It's imposed as a condition of employment. So if you want to take the job, the company says you have to sign this agreement agreeing to arbitrate disputes with the company. And there's really no negotiation at all. It's a term and condition of employment. And that's why we call it mandatory arbitration, because you don't really have a choice if you want the job.
And before we get to these court cases that sort of to layer it in, is this, it seems to me that the introduction of a condition for the job, right? It's always been the case, oh, you want this job? It's 5 days a week. You got to show up at the office. You can't just decide I'm going to do my work from home, or I'm only going to come in 3 days a week. Does the inclusion of this new element, is that an indication of sort of, I guess, of weakening labor power when it's introduced? Is it because this is a fundamental deficit to the worker, and to introduce it, it's almost as saying like, oh, you know what? Now it's just if you want this job, you got to work 6 days a week. What? Right. Is it weakness, or is it just simply that people weren't aware of it?
No, I think it's a little bit of both. People aren't always aware of it, certainly because it's in the stack of papers you get told to sign when you start a job. You're signing up for the health insurance, the retirement plan, office parking, intellectual property, and oh, by the way, here's the arbitration agreement. Sign this, and so people aren't aware of it. But it is also the case that even when they are aware of it, they don't really have the bargaining power to get around it. It's one of the things that is introduced typically for all employees, no negotiation. If you want to be an employee, you have to sign on to this. And it is a little different from just, hours of work or days of the week, right, that you're working, telling you, that, our schedule is, Monday through Friday. You can negotiate over things like your salary or days of work, right? But we can't negotiate to be paid less than minimum wage, or you can't negotiate, away your right against being discriminated against. Right, we don't enforce those agreements; they're illegal. So this is controversial because it touches on our basic legal rights in the workplace.
And so, what was the status of a mandatory arbitration agreement or term, I guess, in the context of a broader employment agreement? What was the status of it in, let's say, the mid 80s? Is this something? Could you put this in the same way that so today there's certain anti-competitive clauses that just simply don't, you can put it in there and you can agree to it, but courts have found that they're just not legal, and so you can't, as a worker, you can't even give that away, right? I can't become an indentured servant even if I wanted to.
Exactly.
Was that the status of arbitration agreements in, let's say, the 80s?
Right. So, so if you go back to the 80s and earlier, some companies had arbitration procedures that they'd use for, internal workplace disputes. But what wasn't the case is that you could require an employee to agree to arbitrate their statutory rights, their civil rights, rights against discrimination, rights to a minimum wage, those kind of things that have been established in law by Congress and state legislatures. Those things weren't subject to arbitration. And so the real revolution was that suddenly mandatory arbitration became something that all of our rights could be subject to, and that is a big shift.
I mean, it also is it founded on the right that you have that all Americans have a right to go to court essentially to deal with their grievances? Yeah,
I mean that is something that I think Americans hold really deeply. The jury trial was, one of the foundational ideas of American democracy. You go back to de Tocqueville, talk about this amazing kind of feature of American democracy. And the jury trial is fundamental, the right to go to court. And this is a real shift that the Supreme Court did to start saying, well, you've got your rights still, it's just you're having them heard in a different forum by a different person. So, it's not really a change. But a lot of people looked at it and said, hey, that sure seems like a big change, right? That we value that right to go to court and right to have a jury of our peers decide our case.
So in this study, basically you tracked the adoption, I guess, of this term. And so track it for us. I mean, what we start to see the court cases in the early 90s that open the door to this.
Yeah.
How quickly did we see this sort of provision catch on? And could you also tell how that happened? I mean, was it just simply, people going to business conferences and are like, incidentally, I mean, how does this something like that grow in usage?
Yeah, so, our best evidence is that, at the beginning of the 1990s, maybe 1 or 2% of employers, hardly any, were using arbitration for non-union employees. And over the course of the 90s through the early 2000s, it had grown to, maybe 20-25% of employers were using this. So that's a pretty rapid growth. And my latest studies indicates that that growth has continued, and it's now over half of employees covered by mandatory arbitration. And how this happened, it was interesting in the sense that there were a bunch of employers who jumped on it right away in the 1990s, who saw these Supreme Court cases and saw this as a way to protect themselves against litigation, against employment lawsuits. And so there were a bunch of early adopters.
Was there a specific profile of those employers? In other words, was it specific industries that were first to adopt this?
So it tended to be employers who had sort of experiences with litigation. So I was studying this back in the 1990s, and some of the industries where you saw it a lot, the securities industry, they were having a lot of lawsuits back in the 90s, and they were certainly one of the earliest places where you saw it being used a lot. I also saw it, interestingly, in the aerospace industry. I was looking at some companies there who had done a lot of layoffs in the early 1990s when there was downsizing, particularly in the defense industry. And so they were getting hit with a lot of lawsuits. They had a lot of older workers, particularly, they'd been laying off, and they were getting hit with lawsuits. And so they sort of really viewed this as kind of a shield that was going to protect them against liability and against these lawsuits.
That's interesting. And so it was really more about circumstances, those who wanted to escape having to account to their employees in that particular time. Did you come across any in the course of now, this is sort of, slightly askew from the focus of the research, but did you get a sense of who was, if there was a concerted effort to, I don't know if it's a question of rolling back certain statutes or, but building the case law so that arbitration was more freely adopted? Was these just a bunch of random cases, or was it the case that there was a real concerted legal effort?
Yeah, I think there was a really concerted legal effort. Certainly in the defense bar community amongst the employer representatives, they saw these cases and the potential that they offered for protecting their clients. And so certainly there's a big part of the story that's about the kind of more sophisticated employers and law firms representing those employers who saw this opportunity to really ward off litigation, that they viewed this as, saving them money. Litigation costs them money, it costs them time, they get dragged into depositions. They don't like that. And this was a real opportunity for them. And in their view, they see sort of litigation as kind of running out of control, and these runaway juries, and the tort reform is kind of part of all that. This was another way that they identified that they could defend themselves. And so certainly there was a series of kind of cases where employers were using this a lot, and their law firms were really pushing these forward to really establish this kind of strong legal basis for mandatory arbitration, to really expand it.
All right, well, Alex, when we got to take a break, but when we come back, I want to talk about how that's been expanded and where it goes from here, and if there are any efforts to roll this back, and if there is a way to roll it back, because and then I also want to just get more concretely into the specific rights that employees lose. We got to take a quick break. I'm Sam Seder. I'm talking to Alex Colvin from the Economic Policy Institute. We'll be right back on Ring of Fire Radio.